The Committee on Criminal Jurisprudence will come to order. Clerk, please call the roll.
Chair Smithy,
Here.
Vice Chair Wu,
You're here.
okay. Representative Bowers, Representative Cook, Representative Jones, Representative Little, Representative Louderback, Representative Money, Representative Moody, Representative Rodriguez Ramos, Representative Verdell.
Okay, a quorum's present. Members, thank you all for being here. We're just trying to squeeze time anywhere we can find it to hear some of these bills. I would just make a couple of comments to begin with. We have a number of people here who've indicated their intent to testify. We welcome anyone to testify. We would ask that if you're intending to testify, that you fill out a electronic witness affirmation outside the hallway in the kiosk. And you can also, of course, fill out an affirmation that you are for or against a bill but do not wish to testify. We are imposing a limit of 2 minutes on each witness, and then the committee members are free to ask questions. And we'll go ahead, members, it would be our intent to go ahead and hear some bills and wait until later on. We'll try to fix a time to take some votes later on today. Obviously, for everyone, I think, on the committee and in the audience is aware that we're supposed to be on the floor at 10 o'clock this morning, and so we'll have to break around 9:30 or a little after to go to the floor, and then we'll resume as soon as the floor is completed. So with that, the chair will lay out House Bill 3694 and recognize Representative Raymond to explain the bill. And also there is a committee substitute, so Vice Chair Wu offers the committee substitute to House Bill 3694.
Thank you, Chairman and members. Good morning. Artificial intelligence is a powerful tool that I believe will lead to great progress in our state and this country and probably in the world. With that power, however, comes a need to safely regulate AI so that it is not used to harm Texans. Generative artificial intelligence is being used to create non-consensual sexually explicit images and videos that are distributed through social media apps. The subject of these false AI posts are then left to deal with the fallout of such a terrible act without proper means of seeking justice. This bill seeks to remedy that situation with three main functions. First, it addresses the distribution of deepfake media on the social media platforms by creating a tool that people can use to remove unauthorized, intimate visual depictions. It would allow an individual to notify a social media platform of a non-consensual post, request its removal, and have it taken down within a reasonable amount of time. The second function expands the definition of deepfake media to address the entire issue. Deepfake media would now include photos and not just videos, which was a prior law. The third function would provide more clear punishments for those that create and disperse these unauthorized intimate visual depictions. Committee Substitute House Bill 3694 would make it a crime to knowingly produce or distribute sexually explicit deepfake media without the consent of the person appearing to be depicted. So the punishment continues to be a Class A misdemeanor, however, which is what we do in the committee substitute. But it would also make the offense a felony of the third degree if the person appearing to be depicted is a minor or if this is a repeated offense. That's all it is, members. Pretty straightforward. It's good, about as good as you can get when it comes to legislation. But if you have any questions, or here I am.
Okay, well, we need to first note Mr. Cook's presence on the record, and Mr. Verdell is present as well.
Present.
Any questions for Mr. Raymond? Mr. Little?
Thank you, Representative Raymond.
Yes.
I'm interested in the civil aspect of your bill, the language where you you provide a notice to a covered platform, where if you got a deepfake on an internet website, it's very similar to the way our defamation statute works now, that you can make a retraction demand of someone who defames you. I think this is a really good mechanism. I was a little bit puzzled as to why the remedy falls under deceptive trade practice, though. So in Section 2 of your bill, it says a violation of this chapter is a deceptive trade practice and is actionable under that chapter. So
Are you asking me why?
Yeah.
I'd have to get Ledge Council here because I don't know why that got put there. I really don't. I assume that as they were putting this together that I don't know. It's a good question, but I really don't know, and I can check on that and let you know in a little while, but I don't know.
Yeah, there needs to be a remedy for it if the
Right.
covered platform refuses to take it down.
Right.
I'm not sure that is the precise one, but really interesting approach to it that I haven't seen.
Well, you know, you're going to see a lot of interesting things here, but I will check on that, and it may. I mean, I don't know. I saw that, and that wasn't something that I sort of directed, but it came in as we worked through the legislation with Ledge Council. But I will definitely follow up with you on that.
Thank you, Representative
To
Brown.
see if this bill passes, if there be any opportunities for you.
Yes, sir. You never know.
Any other questions, members? If not, we'll hang loose. I don't show any witnesses registered, and we'll let you close. But anyone here to testify for, against, or on House Bill 3694? If not, Representative Raymond, if you want to close.
Thank you, Chairman, for allowing me to present this. Members, I'll follow up with you on Mr. Little's question. With that, I really do think it's important that we pass legislation like this. Regrettably, you see it more and more, and it's terrible. It's just terrible. And not only do you see it more and more, but you see it more and more with younger and younger, where it's happening to younger and younger people, and we got to do something. So with that, I close, Chairman.
Okay, thank you, Mr. Raymond, and we'll at this point leave House Bill 3694 pending. The chair would, well, first of all, the chair would withdraw the committee substitute and leave House Bill 3694 pending. The chair lays out House Bill 4254 by Representative Metcalf and would recognize Representative Metcalf to explain the bill.
Thank you, Mr.
And
Chairman.
there is a substitute. Let me,
Yes,
Mr.
sir.
Cook lays out the substitute to
Thank you, Mr. Cook.
House Bill 4254.
Thank you, Mr. Chairman, members. Good to be with you this morning. Under current Texas law, judges may declare a mistrial in a felony case after the jury has been sworn for reasons such as a violation of discovery rules, Article 39.14, Code of Criminal Procedure, legal error, misconduct by participant, or improper admission of evidence. However, the Code of Criminal Procedure does not currently require the trial court to explain the specific legal or factual basis for such a decision. Likewise, current statutes do not provide the state a clear statutory right to appeal a mistrial order entered into a jury that is sworn. Prosecutors across Texas has raised concerns that mistrials are sometimes granted without sufficient justification or record, making appellate review difficult and allowing potentially improper terminations of trial. If a judge unilaterally declares a mistrial without considering less drastic alternatives, there may not be manifest necessity for a retrial. In such cases, the state may be barred from retrying the defendant, who would receive the windfall of an effective acquittal. The Code of Criminal Procedure sets out no limitations on a court's authority to grant or declare a mistrial, and the state currently has no right to appeal from a mistrial order. Committee Substitute House Bill 4254 provides valuable guidance to trial courts by prohibiting mistrial orders, which are necessary to protect a defendant's constitutional rights. This bill requires the court to make specific findings of fact and conclusions of law regarding the necessity of a mistrial, and it enables the state to initiate an expedited appeal when a trial court unnecessarily terminates a trial. If a court fails to provide those findings, the order is presumed to lack a legal or factual basis and becomes subject to reversal. The bill also requires that such appeals be expedited and prioritized in preparation and review. The committee substitute simply makes this bill a Ledge Council draft. Members, let's ensure that mistrials are granted only when absolutely necessary and that courts are held accountable through a clear appellate process. We do have some members available to take testimony for you all for specific. I'm not an attorney, I'm a banker, so I would love to take your questions and reserve a right to close if that's okay, Mr. Chairman, members.
Certainly we will. Any questions for Mr. Metcalf? If not, we'll go ahead and call the witnesses.
Thank you, Mr. Chairman, members.
We have Allen Place. and you've registered as Alan Place on behalf of Texas Criminal Defense Lawyers Association against the bill?
That's correct.
Okay.
Thank you, Mr. Chairman. Just a couple of notes. Before I finish, I do have a couple of suggestions that we think will help in terms of the stated purpose of Chairman Metcalf. But I do want to call committee's attention to basically 3634 in the first paragraph in the Bill A. Basically what I would suggest to you today, the test for a mistrial is a totality of circumstances that a judge is going to have to make a decision, and it's not an easy decision. It's not an AI decision. It is a person that is basically taken an oath and is in charge of the trial and is there when the actionable statement or whatever it was occurred, okay? And so that is a very serious matter. As I read A, what we're doing here is we're now changing the test from the judge to basically saying the judge can't grant a mistrial unless there's no lesser remedy. There's always going to be the potential of a lesser remedy, and so the test is whether or not a fair trial is done, not whether there's a balancing of remedies, in our opinion. The second part is we don't have any problem with there being a written request or requirement for findings of facts, conclusions of law, but I've never seen anything written that says it has to be immediate, and then failure to do so provides an irrebuttable presumption, which we think could probably cause some due process issues. So number one, if you want to have findings of fact, conclusions of the law with a reasonable time period, and if this body feels this is something that should be appealed, then that's fine.
Have you visited with Mr. Metcalf at all?
I have, I'll be honest with you, I've talked to his staff. I'm going to have some
Okay.
suggestions. This is brand new. I've never seen anything quite like it, and trying to get some language that I think he could live with. It really took me till last night to get it to that point.
Okay.
And I certainly will.
Okay, well, thank you. Any questions for Mr. Place? Mr. Wu?
I think it may be necessary to be said that criminal procedure, criminal cases are not the same as civil cases. The parties are not at equal standing
I think that's true.
in a criminal case.
I think that's
in a
true.
criminal case, the prosecution is the only person who can file a charge, right?
Yes, yes.
The prosecution has the sole discretion of when and where to file charges and who to file charges on. The defense doesn't have that option,
Correct.
right? And in a mistrial, the prosecution's tool in a mistrial is refiling the case,
Correct.
right? And in Houston, we've had cases go to trial 3 and 4 times because of mistrials, and you just plow through it, and you do what has to be done. And I think one of the things about this is that because the state holds all the cards in this endeavor, like the state is responsible for the investigation, they hold the evidence, they file the charges, they determine, all sorts of different things in this process, that this would be like an additional tipping of the balance. Would that be fair?
I agree.
Thank you.
Okay, any other questions? Mr. Little?
Alan, thanks for being here. I don't understand this bill. I don't understand what the outcome would be if you had the ability to overturn a mistrial. So the court enters findings, fact, and conclusions of law, goes up to Court of Appeals. Court of Appeals goes, you know what? You're right. This judge shouldn't have granted a mistrial. And then what? Do we round up the same 12 jurors and say, you guys all need to come back? Because I've had one mistrial in my career in a civil jury trial, and the effect of it is you just start over with a different jury. So what is the remedy here if a trial court granted a mistrial wrongfully in a jury trial? That you have to go round up the same 12 people?
That's true.
I don't understand.
I will say Chairman Metcalf's bill has made me think more than a person my age should probably think. It has been a really it is a difficult proposition to think through it. I had the same question and what I believe is possible, and I believe there may be a case, maybe within a 90-mile radius here, that had a similar situation. They took something up on appeal, and my understanding is they have the same jury panel, just they went home and everybody goes on their way, but they may be subject to being called back depending upon when that matter is resolved.
What if one of your jurors dies or reads something about the case in the newspaper and becomes disqualified in the interim? I don't understand what the remedy is. I do believe that mistrials can be wrongfully granted, like a judge could have a bad day. That happens. Sure. I think the mistrial in my case was wrongfully granted, but there's no harm on, like, if it is an error, it's a harmless error because you start over. You can't say, well, I had a really good jury, therefore that's my harm. I don't understand. Maybe somebody else does better than I do.
Well, I think the only way I could see if it went up is that the court would literally have to tell the same jury to go home, whatever the instructions are, as if they were, in my opinion, almost deliberating, and not to listen to this or that, and we'll call you when needed, which, depending on the appellate courts, could be a while.
2 years?
It could. I think that's probably modest.
I mean,
in some cases.
On mine, maybe John Smithy's moved faster than mine, but mine would take a couple years, seems like.
I understand.
Thank you.
Well, I will say, if you look at the current law, which is in Section 2, it talks about the things the state can appeal. And so I don't think it's totally out of line, because I think in some cases, if there winds up being a dismissal or something, that could go up. But it is a little bit awkward in terms of what are you going to do with that particular jury panel.
Well, none of those other categories, Alan, rely on the existence of a jury. So I'm just thinking in an interim of 2 years, when you have an appellate process, jurors can become disqualified in that period of time. So I just don't understand the remedy. Thank you.
It would be a little unusual, yes,
Yeah.
sir.
Ms. Jones?
I know this is not your bill, and you trying to understand it, per what you said, and your brain is working way more than it should at your age, which you said I didn't.
It is today.
I don't understand, as Rep. Wood said and as Rep. Little has said, the remedy is you just retry the case. You decide. But I can tell you my experience. I haven't had a mistrial, but I can tell you whenever I've gotten not guilties or something wasn't ruled like the state wanted, they complained. There was always an excuse for why they lost, always. And I believe that the Constitution is clear that the state has the burden beyond the reasonable doubt. And I'm going to go back and I will say this forever. This country was founded because the government was oppressive in England, and it had all the benefits of the doubt. And the state has that burden for a reason, because they're taking away the most basic liberty, which is the freedom to live your life as you want in America and achieve the American dream if you can. And so this would, in my respectful opinion, would tilt the scales in favor of the state, which, as Rep. Little has said, and Rep. again, Wu has said, is they have all the benefits. So I don't know why this bill would undo, like, the whole way our criminal justice system is. And I think it potentially is a violation of due process for that person charged with a crime, accused of a crime. And I'll also say this. The times that I've seen a mistrial, the state hid evidence or something like that, and they wanted to have trial by ambush, and it didn't work. If the judge grants a mistrial for that, then at least then the defendant doesn't have undue surprise. It's not trial by ambush. It allows the parties to start off exactly where they are. So I don't. And so one thing I would like to know from you, because I just don't think that this bill passes constitutional muster, but you said that you maybe had some language you thought.
Well, I think, number one, I would say most mistrials, and they are rare. I don't know that, let me back up. I believe either party could ask for findings of facts and conclusions of law. So if this committee wanted to make it certain that there would have to be written findings of facts and conclusions of law in a reasonable period of time after the granting of the mistrial, we don't have any problem with that,
Well,
okay?
Let me tell you why.
Because
I would-
they may be oral before written. I don't know that would be a
But let-
difference.
But let me tell you why I have a problem with that. You have deadlines that you've got to meet in order, like, to perfect appeal. You've got to file a motion for new trial. You've got to file a notice of appeal within 30 days, right? If that's what you have to do, then do I have to wait until the findings of fact and conclusions of law are drawn up? I mean, is that going to affect my ability as a criminal defendant to, I mean, they're just issues I see. So,
Well, our
and Washington, the state, they can just ask. They can either do an oral motion for the judge to do a findings of fact or conclusions of law, or the state can just draft a written motion, findings of fact and
I do.
conclusions of law.
I believe they can do that
So-
today. I think this
so why do we need to put
this
it-
clarifies if there's a question out there, but I believe they can do that today. I do agree with that.
Well, they can do that.
Absolutely.
So why, I mean, if the state doesn't have the whatever to ask for it, then
Well,
That's on them.
as I read this would have to be done immediately, however that is defined, and there's a penalty if it's not done immediately. And in our world, in courts, immediately, I don't know that there's a definition of that. If it's a reasonable period of time, like you normally would be given on findings of facts and conclusions of law, that would be something that would be more reasonable in our opinion, if you went that way.
I also think it would just slow down the administration of justice in a court. I mean, because you've got dockets. It's more, like I said, it's more administrative work for the court, which necessarily implies that other things will be pushed back. But I like Rep. Little, don't understand this bill as a criminal defense lawyer for a whole bunch of years.
It has some moving parts, I'll give you that.
Mr. Verdell? Jim?
Not a lawyer, just a simple question.
Sure.
If this passes, is it a benefit to the state or to the defense on?
Well, let me just tell you, a mistrial, depending upon where you are on either party, I'm not sure there's a perfect answer. Sometimes a mistrial is granted and the state may be thinking this may be a good thing because this wasn't going well, or vice versa. Okay. The issue is that currently a mistrial is granted basically if a court makes a finding that something has happened in that courtroom that the person cannot get a fair trial. Okay. And so whether that benefits one side or the other, in my opinion, is really not the question. The question is the court has made a decision, and I'll assure you, this is done rarely. It's not something that I think any judge ever does lightly. It's after serious thought. And so I don't think it's as much tilted one way or the other as just trying to find out how we're going to do this right.
Yeah, copy that. Thank you. Appreciate it.
Okay, anything else? We've got a couple other witnesses, so thank you, Mr. Place. We have Amy Waddle. Waddle, you are registered, Amy Waddle, Assistant District Attorney. You're here on behalf of the Montgomery County District Attorney and yourself testifying for the bill. Is that correct?
That's correct. Thank you. Today I'm asking for your support for HB 4254. It's a bill that brings much-needed balance and accountability to the way mistrials are handled in felony cases. A mistrial brings trial to an abrupt and early end. It could be before opening statements. It could be after both parties have presented all of their evidence. And it requires the case to start over before a new jury sometimes. This can be costly, time-consuming, and burdensome for all parties involved. A trial judge can declare a mistrial for virtually any reason or no reason at all, and there's no way to challenge that decision. As Representative Little pointed out, judges are human, and even the most even-handed jurists can succumb to the pressures and frustrations that arise during trial proceedings. But if, in a moment of exasperation or for the sake of convenience, a mistrial is declared unnecessarily, there is no existing mechanism to review that decision. Meanwhile, if a judge denies a defendant's request for a mistrial, that decision is appealable. In other words, there's accountability for judicial restraint, but no accountability for judicial excess. The harm Representative Little was asking about is that in some cases, if a judge grants or declares a mistrial absent what courts call manifest necessity or the defendant's request, then that can bar a retrial under the constitutional double jeopardy and due process rights of the defendant. And so there is a harm at not having those decisions be reviewable. And this bill just gives oversight to the decisions that judges already make and ensures that extra layer of review to be sure that mistrials are only being granted when appropriate and that cases are not being barred from retrial unnecessarily.
Mr. Little?
Ms. Waddle, thanks for coming to testify again. Just lay out for me the circumstances in which retrial would be barred on a mistrial.
So a retrial would be barred if the defendant himself didn't consent to the mistrial, or if there was no manifest necessity. Manifest necessity is something that's kind of a creation of the Supreme Court, and there are lots of different circumstances that can constitute that. But generally, it has to be an extraordinary circumstance that would make continuing the trial impossible, reaching a fair verdict impossible, or yes.
Where do I find that? Is it in the code?
No, that is Supreme Court case law. And that is, they've held that a defendant's due process rights and right to be only succumb to jeopardy once require that a mistrial only be granted in such extreme circumstances that a retrial is constitutionally permissible before a different tribunal.
Yeah, and I'm sorry, I haven't tried these cases like you and Vice Chair Wu have, and I don't understand. It's my understanding, similar to what Vice Chair Wu had said, that you have a mistrial case is going to be retried until we get a result. I'm still not sure I understand the circumstances in which you wouldn't retry the case. Have you had a situation where you've been unable to retry after a mistrial?
We have. We had a judge who granted or who unilaterally declared a mistrial. The defendant didn't request it or consent to it. And the state even told him, Judge, there's no manifest necessity for this. We think that this is going to bar retrial of the case. And then sure enough, he did it anyway because he didn't want to keep the jurors on the hook. So it was kind of a matter of convenience. And he did it anyway. And then sure enough, when the case came back up for retrial, the defendant filed a motion to dismiss based on double jeopardy. And it went all the way up to the Court of Criminal Appeals. And we were barred from retrying that case.
So the only way you could retry in the case of a mistrial is if the defendant consents, basically.
Or if there's manifest necessity, which is what I was talking about, the extraordinary circumstances, such something that would make continuing with the current jury impossible, or that they wouldn't be able to reach a fair verdict.
Do you have examples of what a manifest necessity is?
Yes.
I don't know what the Supreme Court has said about it, so I'm sorry to put you on the spot, but...
Right. So there have been a lot of instances that have developed through case law, generally like something that couldn't be solved by, for instance, a brief continuance or an instruction to disregard. So, for instance, if a witness says something and it's prejudicial to the defense, if an instruction to disregard would cure it, then that's not manifest necessity for a mistrial. And a judge unilaterally declaring that could bar the state's ability to retry the case. And the state has no recourse. We could be telling the judge, don't do this. This is not manifest necessity. But then we're still the ones that are barred from retrying the case if he persists in making that decision.
Okay, thank you. That's a good explanation.
Any other questions, members? Okay, thank you very much
Thank
for
you.
being here. We have Laura Bond. Ms. Bond, your affirmation shows that you're the chief prosecutor in the Montgomery County District's Attorney's Office. You're here on behalf of the office, the District Attorney's Office, and yourself, and you're for the bill, correct?
That's correct.
Okay.
Good morning, y'all. I'm just here in support of this bill and would ask you all support. I am here as a resource. I am a chief prosecutor at Montgomery County District Attorney's Office, and I have recently been in a situation in which a judge granted a mistrial, which I think prompted the pursuant of this bill. And if you all have any questions, I'm here to answer those.
Any questions from Ms. Bond? Yes, Ms. Jones?
Would you agree with me that mistrials are rare?
I think that's fair.
Would you agree with me that the state has the burden beyond a reasonable doubt to convict somebody?
Absolutely.
So you think that every time a mistrial, in the rare instances that it is granted, the state should be able to retry?
In every instance?
Yeah.
I don't think in every instance, Ms. Jones. I do believe, though, that the courts need to have accountability, and the state should have an opportunity to respond when they do grant a mistrial.
But for the most part, the courts do have accountability, because if a mistrial is granted and the state doesn't like the result, they can retry it. And sometimes the state does some stuff that that requires a mistrial, and it's so bad they shouldn't get a second chance to do that, because jeopardy should attach, because if they would have done what they were supposed to do in the first place, then there would have never been a mistrial granted.
Ms. Jones, I agree with you in that, and I do think that sometimes things happen when they shouldn't, and I believe that in situations where the state has done something that they shouldn't have and a mistrial is granted, that that's appropriate remedy. But I am here in the instance where judges need to be held accountable, in the instance where it is not appropriate for them to grant a mistrial.
So in the rare instances, what you're saying occurs, you want a whole law for it, a whole new law.
I
that
just
for
want
the
a
most
remedy,
part
because there's
changes.
resources that are wasted if the state does need to retry that case.
However, you can ask for findings of fact and conclusions of law without this bill passing. Is that not true?
I can ask for them, but there's no remedy for a mistrial, because at this point, the state does not have the ability to do so, to appeal it. It's just giving us another mechanism in the rare instances that it does happen to be able to move forward.
Thank you.
Yes, Ms. Jones?
Any other questions? Oh, Mr. Cook?
I think it may be helpful for you to briefly talk about the case that you were referring to. I mean,
Yes, sir.
We're limited on time, so don't give us the.
Yeah, I won't, and I am a little limited because that criminal case is still pending. That we are going to retry that beginning Monday, actually. That was a case in which we had a very litigious defendant who was representing himself. He was indicted as a habitual felon, facing 25 to life. Tensions were high, frustrations were high among the state, the defendant, and the court. And the judge granted a mistrial without hearing response from the state, which is requiring us to try that case again.
Thank you.
Yes.
Okay. Anything else, Ms. Jones?
So even in this case, you got to retry it. You
We
get to
are-
retry it. Starts Monday.
We do, but we also have 8 cases behind it, many sex cases. And this case could have been tried if we would have had the opportunity for the judge to hear us out and for us to respond before he granted that mistrial.
Right, but you still are retrying it starting Monday, right?
We are wasting another jury panel.
I think the Constitution doesn't, I mean, if it was constitutionally sound, I don't think it's a waste of a jury panel. I think that.
Which is why
I
the
think
state
that-
is retrying it, Ms.
Hold up,
Jones.
I'm not finished. I
Yes,
think the
ma'am.
Constitution is more important than any one case. I mean, it is like a sacred document, with amendments, because I wouldn't be a person without amendments.
Yes.
But I think the Constitution is why this country was founded on that, and I think that we should always err on the side of protecting the Constitution and due process. But thank you.
Absolutely. Yes. Thank you, Ms. Jones.
You're welcome.
Okay, anything else, members? If not, thank you very much for
Yes,
being
sir.
here.
Thank you.
Chair calls Amanda Marzulli. And Ms. Marzulli, your affirmation shows your name's Amanda Marzulli. You're Policy Director for Austin Community Law Center, and you're here on behalf of the Law Center and yourself, and you're against the bill, correct?
Yes, Your Honor. Thank you, Mr. Chairman. And I apologize to Representative Metcalf. I have not met with him. I wasn't planning on testifying on this bill. As a former death penalty practitioner, I have moved for mistrials in a number of different contexts, and none of them were due to things that happened in the courtroom. And I think it's really important for the committee to know that, you know, as defense attorneys, we also, like prosecutors, are real people. So one of the cases where we had to move for a mistrial, the lead counsel, it was a death case, had head trauma. He fell in his bathroom. He had a concussion. He was critical to the case, but he couldn't show up and represent his client. And the judge was ordering him to do so. So we really had to put the facts on the record to show it was impossible for us to move forward under those circumstances. We even had to intervene in that case. And in another case, this was in federal court, my co-counsel's daughter died in the middle of the case. And he, she was 3 months old, he was shattered. There was no way that we could move forward, and there was no way that I could handle it personally. And it would have been really difficult to respond to the findings of facts and conclusions of law in an immediate fashion the way this bill requires right now. So I think it's really important.
Okay. Any questions for Ms. Mercer? Appreciate your input. Anyone else here to testify for or against or on House Bill 4254? If not, the chair recognizes Mr. Metcalf to close.
Mr. Chair and members, I thank you all for the lively discussion we've had this morning, and I'd be happy to work with each and every one of you to see what we can do to remedy your concerns if you have any, and we'll discuss more about this. Thank you,
Okay.
Mr. Chairman, members, for your time today.
Thank you, Mr. Metcalf. And if there's no objection, members, the chair will withdraw the substitute to House Bill 4254 and leave the bill pending.
Thank you for your time.
Thank you, Mr.
Appreciate it.
Mr. Dutton, are you ready? Yes. And so the chair would lay out House Bill 2728 and recognize Representative Dutton to explain the bill.
Thank you, Mr. Chairman, and members of this committee for hearing this bill. One of the obligations, and I know I don't have to tell you this, is that this committee has is to eliminate or minimize the number of wrongful convictions. And this committee has done a lot in that regard, particularly with the passage of the Michael Morton Act, which occurred a few sessions ago. But this bill, 2728, does essentially that again, adds another tool in our toolbox to prohibit and minimize and eliminate, if possible, wrongful convictions. And it's a doctrine called the spoliation of evidence doctrine. Now, this doctrine actually started in the criminal courts on the criminal side, but what happened is it got used less on the criminal side and is used more on the civil side. And essentially what this bill does is simply says that if evidence is destroyed, altered, or lost, there are several things the judge can do, one of which is to hold a hearing outside the presence of the jury and make a determination as to whether or not that evidence was destroyed, altered, or lost intentionally or knowingly. And on one side, the judge can decide to instruct the jury that the evidence that's not present would have been favorable to the defendant. On the other side, the judge can also, according to this bill, actually dismiss the whole case because of the destroyed, altered, or lost evidence. And I won't belabor the whole point, but that's essentially what the bill does. And so I'll be happy. Probably all should stop and just answer any questions you might have, Mr. Chairman and members.
Okay, let the chair note that Ms. Bowers is present. Any questions for Mr. Dutton? I don't see any, so, and hold on tight. We don't have any witnesses registered, but let me ask, is there anyone here to testify for, against, or on House Bill 2728? Seeing none, Mr. Dutton is recognized to close.
Thank you, Mr. Chairman and members. I think this is another tool in the toolbox to minimize, if not eliminate, wrongful convictions, and so I leave it to this committee, and I close.
So if there's no objection, Ms. Jones has a question.
So every now and then I see you in the criminal courts in Harris County.
Well, I try to hide.
And so
In what
you
capacity, Ms. Jones?
represent
Not as
people.
a defendant,
You keep
though.
getting clients, so he must be doing a good job. So we know in Harris County, there's a worksheet that says we destroy all evidence and things.
Yeah, and that generally comes after the case has
Right
been,
after the case is
been
pending.
resolved, yes.
So this doesn't have anything to do with that?
Oh, no.
Okay.
This would occur This would have something to do with before the trial of the case, actually, where a judge could hold a hearing based on the pleading by the defendant that some evidence had been lost, destroyed, or altered that would have been exculpatory to that defendant. And so that's what this bill is about. This is not about the...
Because I've had a situation where I learned of something before trial started, in the morning of trial.
Right.
But prior to impaneling a jury,
Right.
I approached the judge related to the evidence that was hidden, that I learned about and had a copy of, even though the state didn't give it to me. And when I approached the judge, the state called, asked the judge if they could have a moment, and unbeknownst to me, they went and dismissed the case. And then when we came back, the state's argument was, well, Judge, that's moot, the case is dismissed. So.
I had a similar experience. I thought you were talking about my case almost.
Okay.
But yeah, I had a similar experience, and that's really what this bill is about, is making the state fess up to making sure that the evidence, that certainly evidence that would be exculpatory to the defendant, is actually given to the defense counsel. And sometimes that doesn't happen, and I don't comment on whether or not it's intentional or knowingly or negligent or reckless, but it does happen, and so this just provides a remedy for that.
Thank you.
Any other questions? Okay, if there are no other questions, the chair will, no objection, the chair will leave House Bill 2728.
Thank you, Mr. Chairman.
And the chair lays out, you've got one more. Let's see,
Yes.
the chair lays out House Bill 2239, and once again recognizes Representative Dutton.
Thank you, Mr. Chairman and members. This is more of a technical correction than anything else. In 2017, I passed a bill that, well, it's kind of funny, but what happened is, in the committee, real briefly, I had an idea that we needed to have a discussion about what was on the prohibited weapons list, and I thought that would be a good idea. So what I did to foster that was I had a bill that would eliminate switchblade knives from the prohibited weapons list, because I thought, well, switchblade knives are on the list, but AK-47s are not. And that just seemed so strange to me. So anyway, I introduced that bill, and without my, unbeknownst to me, when the time of the hearing came, there were about 20 witnesses, and I asked the committee chair at the time who all these witnesses were, and they were actually for the bill, all of them. And so we ended up passing the bill that basically said where certain knives could be carried, particularly based on their length. What we failed to realize is that there are some establishments, particularly establishments that sell beer, wine in them, that where the employees end up doing all kinds of cutting of things, and they happen to be above the 5-inch blade requirement that was limited to these establishments. And so this bill just corrects that so that it doesn't affect those employees.
Any questions for Mr. Dutton? Okay, we've got a few witnesses. We'll call those and
All right,
certainly
thank
permit you to close. We have Todd Rathner. Mr. Rathner, your affirmation shows that you are here as director, in the capacity of Director of Legislative Affairs for Knife Rights, and you're for the bill, correct?
Mr. Chairman, that is correct. For the record, my name is Todd Rathner. I represent an organization called Knife Rights. I was one of the 20 witnesses that spoke in favor of Mr. Dutton's bill years ago. I think it was way back in 2017. And Mr. Chairman, members of the committee, thank you for allowing me to testify in support of HB 2239 today. This committee and the full House has passed this bill numerous times in a bipartisan way, and the Senate has passed it once, just not in the same session. Typically, it's my job to answer questions when I testify in this committee. This time, I'm going to ask you a couple of questions. Are you aware that it's illegal for anyone to possess a knife with a blade over 5.5 inches in a 51% establishment even kitchen workers. Almost every single 51% establishment in the state has a kitchen. Every single person that possesses a typical average kitchen knife in the kitchen is in violation of the law, including the owner of the establishment. It's nuts. If these folks are bringing it back and forth, or even if somebody wanted to prosecute them, they could. We need to fix this. It's the result of an amendment that we had to accept years ago. The problem has been solved. We need to solve this part of the problem now. With that, I would answer any questions. This just needs to be solved. It is a technical correction. This is the fourth or fifth time we've tried to fix it. As Mr. Moody knows, he's been around trying to help us with this for years. Mr. Dutton, of course, has been trying to help us for years. We need to get this fixed. This body has never been the issue. I'm really hoping that we'll get it out of here one more time and give the other body another shot to try to get this thing done and help those people that work in kitchens who should not be prosecuted for carrying a tool that they need to do their jobs. And with that, I'll conclude.
Okay, any questions for Mr. Rathner? We appreciate, Mr. Louderback has a question.
Thank you, sir, for testifying. What's been the opposition?
Mr. Chairman, Representative, there has been no opposition. I believe this is the fourth or fifth time that we've run this, fifth time according to one of my colleagues out here. It's been bipartisan. It's been on the consent calendar. This bill. There's no controversy. I'm not really sure what's going on, why we can't get it done. But I've been doing this for a long time, so I know that there are some things that happen here and there. Maybe this is going to be the year. I really hope this is the year. It's just not fair to the folks that are working in these kitchens. They have the knives. They're required to have them. Even the owner, there's no exception. But no, there's been no opposition to it. We just got to get it moved through and do the right thing for the folks that are working in these kitchens.
Any other questions?
Thanks, sir.
Thank you for being here.
Thank you, Mr. Chairman.
Chair calls Richard Briscoe. Mr. Briscoe, your affirmation shows that you're here. Your name is Richard Briscoe. You're here testifying on behalf of Open Carry Texas and yourself, and you are for House Bill 2239. Is that correct?
That is correct, sir. Thank you, Mr. Chairman. In the interest of brevity, I will associate myself with the remarks of Representative Dutton and Mr. Rathner. This really is a simple bill. It empowers employers to allow their workers to bring the tools of their trade to do the job they were hired to do and still restrict anyone else in any manner they see fit. It's a law that hardly anyone knows exists. And with that, I will conclude my remarks and answer any questions.
Thank you, Mr. Briscoe. Any questions, members? Thank you for being here.
Thank you, sir.
Chair calls Susan Stewart. Susan Stewart here? Okay, Ms. Stewart registered on behalf of herself for the bill, but she will not be shown testifying. Is there anyone else here to testify for, against, or on House Bill 2239? If not, Chair recognizes Representative Dutton to close.
Thank you, Mr. Chairman. I close.
Okay. Thank you very much, Mr. Dutton. If there's no objection, the chair will leave House Bill 2239 pending. So the chair would, Ms. Forrest, are you ready? The chair would lay out House Bill 3566 and recognize Representative Flores, and Representative Rodriguez Ramos lays out the committee substitute to House Bill 3566. Go ahead. Go ahead.
Good morning, Chair Smithy, Vice Chair Wu, and committee members. Thank you for the opportunity to speak to you about HB 3566 relating to the frequency of county bail bond board meetings. Mr. Chairman, thank you for laying out the committee substitute that was reviewed and revised by Legislative Council, but is otherwise identical to the introduced version. Members, county bail bond boards conduct hearings and investigations and make determinations relating to the issuance, denial, or renewal of the licensure of bail bonds, bail bondsmen operating within that county. Statute stipulates who must sit on county bail bond boards. These stipulated members include a representative from bail bond industry, the sheriff, a district judge presiding over criminal matters, the county judge, the district attorney, the district clerk, and the county treasurer. Statute requires bail bond boards to meet monthly. Boards in counties with populations under 150,000 have an exception to be able to meet at least 4 times a year. Past meetings of the Travis County Bail Bond Board reflects very little new business that must be deliberated by the board at their meetings. In fact, often there's no new business at all, but the board must meet regardless of if there is any new business to dispose of. The Travis County Bail Bond Board requested this bill in order to consolidate meetings for efficiency's sake. The Bail Bonds Association requested several stipulations in the bill that were agreed upon and are reflected in the bill language. These include stipulated months for meeting, as well as a license renewal holdover provision currently available in smaller counties to licensees applying for renewal of their license. Committee Substitute House Bill 3566 was carefully crafted only to impact the Travis County Bail Bond Board and is the result of collaboration with representatives from the bail bonds industry. With that, members, a representative from the Travis County Bail Bond Board is in attendance and can speak to the need for this legislation. I respectfully reserve my right to close. Thank you.
Thank you, Ms. Flores. Any questions for Ms. Flores? Okay, we'll go ahead and call the witness, and we'll give you the right to close. The chair calls Dolores Ortega-Carter. Ms. Carter, thank you for being here. Your affirmation shows that you are testifying today in your capacity as Travis County Treasurer, and you're for the bill. Is that correct?
That's correct, sir. Good morning, Chairman Smithy, Vice Chair Wu, and committee members, Sheriff. My name is Dolores Ortega-Carter, and I am the County Treasurer for Travis County. I am here to support and testify in support of House Bill 3566 by Representative Flores. I'm a member of the Travis County Bail Bond Board, currently serving as the chair. Statute requires the county treasurer to sit on the county bail bond board, and as a member of the bail bond board, we approve and renew licenses for bail bond persons. The statutes require us to meet once a month. The Travis County Bail Bond Board often doesn't have any official business that needs to be taken care of at a monthly meeting. There are far less frequent license applications and license renewal applications that come through the Travis County Bail Bond Board than any other of the county boards. So the Travis Board is challenged to meet quorum requirements. The board decided to pursue the filing of HB 3566 because of this, and we are very appreciative of Representative Flores for filing this bill to help the board of Travis County to have a more efficient meeting schedule. I want to highlight that the bill would give us the ability to call additional meetings should we begin to receive more applications. And the bill will also allow expiring licenses to remain active until the next meeting, which is flexibility that currently does not exist for our board. I think it is important to point out that the bail bond boards must have a representative from the bail bond industry on the board, and our industry board member voted in support of pursuing this legislation. I appreciate the committee's time hearing this bill and hope for your support for a more efficient meeting schedule for Travis County Bail Bond Board. I'm happy to answer any questions that you may have.
Okay. Members, any questions for Ms. Ortega? Mr. Louderback has a question.
Thank you for testifying. Can you give me a number of how many active bail bond companies you have?
Currently, we have about between 12 and 15.
Is that adequate?
I'm sorry, give me bail bondsmen in Travis County?
Yes.
Yes, sir, about 12.
Thank you.
Yes, sir.
Ms. Jones?
Yes, ma'am, thank you for coming. So you're asking to not have to meet once a month. You're asking to meet, so this is a local bill?
Yes,
Is this
ma'am.
a local bill? So this
Yes.
is a local
Yes,
bill,
Ms. Jones.
and you're asking to meet I guess once every 2 months, or if the presiding
Correct.
officer needs to call more.
Correct, yes, I
Okay,
will.
and that's
Yes.
it. Okay, thank you.
Yes, ma'am, thank
And
you.
a question,
Okay.
is this, I see the population brackets.
Yes.
Is that specifically
That's
to?
this is specific to Travis County.
Okay, that's
Yes,
what I was
ma'am,
wondering. Okay.
thank you.
Thank you very much for
Thank
being
you.
here, Ms. Carter. Anyone else here to testify for, against, or on House Bill 3566? Seeing no one, Ms. Flores can make, recognized to close.
Members, thank you. This bill will allow efficient administration of the Travis County Bail Bond Board. Thank you for your time, and I close.
Okay, thank you, Ms. Flores, and if there's no objection, the substitute will be withdrawn and the bill will be left pending for now. We'll try to get these bills out as soon as possible. Mr. Hayes, are you ready? At this time, the chair the chair lays out House Bill 3206 and recognizes Representative Hayes, and Mr. Cook lays out the substitute to House Bill. Oh, there is no substitute on it. So Chair recognizes Mr. Hayes to explain the bill.
Thank you, Chairman and members.
Appreciate your waiting.
Not a problem. For decades, Texas law has required courts to sequester juries in felony cases upon the motion of either party. This mandatory sequestration can create significant logistical challenges and costs for court systems, particularly in rural counties with limited facilities. In many cases, sequestration may not be necessary to ensure a fair trial. House Bill 3206 amends Article 35.23 of the Code of Criminal Procedure to modify jury sequestration practices in Texas by removing the mandatory requirement that a court must sequester a jury upon motion by either party. Instead, the court will maintain discretion to order sequestration on its own motion when circumstances warrant, and it establishes a good cause standard for jury sequestration when either party requires. This change provides courts with greater flexibility while still preserving the ability to sequester juries when truly necessary. The bill ensures that sequestration is used judiciously, reducing unnecessary burdens on our court system while maintaining the integrity of the trial process. Thank you, Chairman and members. I yield and reserve my opportunity to close.
Any questions for Mr. Hayes? And I know there's a Senate bill companion on this. Do you know where it is in the system right now?
I do not.
I will check and see. Any questions? If not, let me hang there because I don't show any witnesses, but I'll just ask, is there anyone here to testify for, against, or on House Bill 3206? If not, Chair recognizes Mr. Hayes to close.
We close.
Okay. Thank you. And if there's no objection, the Chair will leave House Bill 3206 pending. We're out. Oh, Mr. Manuel's here. Okay. So the Chair would lay out House Bill 3744 and recognize Representative Manuel.
Good morning. Thank you, Chairman and members of the committee. HB 3744 updates the definition of intervener under the Crime Victims Compensation Statute to match plain language in real-life scenarios. The bill replaces criminally injurious conduct with criminal offense, making it easier for survivors and their families to understand eligibility without requiring legal interpretation. HB 3744 does not expand or restrict who qualifies. It simply makes the law more understandable and accessible for crime victims and those who help them. I know we have a resource witness, and if unless there are any questions for me, I reserve the right to close, Chairman.
Well, I don't have anyone. Well, first of all, are there any questions from Mr. Manuel? I don't show anyone to testify, but let me just ask, is there anyone here to testify for, against, or on House Bill 3744? If not, the Chair recognizes Representative Manuel to close.
Thank you, Chairman, and I close.
Okay. And any other questions? Okay. If there's no objection, the Chair will leave House Bill 3744 pending.
Thank you.
Thank you very much. Mr. Moody, are you ready to, I hate to ambush you.
I will try my best.
Now, you've got two bills. Any preference?
Dealer's choice.
Yeah, is 4915 okay?
That's perfect.
Okay. So the chair lays out House Bill 4915 and recognizes Chairman Mr. Moody to explain the bill, and Mr. Wu offers the substitute to 4915.
Thank you so much. Mr. Chairman, members, House Bill 4915 is an omnibus bill for the Texas Indigent Defense Commission, which the chairman and I serve on as ex officio members. The bill reflects consensus provisions that have broad agreement, and its identical Senate companion is on the way to us with no opposition. The substitute you have in front of you removes a number of sections of the bill that would have created grant and loan forgiveness programs. So what we're left with are a variety of technical tweaks to improve indigent defense in Texas, along with no fiscal note. I want to hit the top line issues on this bill. Section 1 impacts appointed counsel for certain writs of habeas corpus. Section 2 is a magistration statute cleanup. Section 3, limited scope appointments at magistration. Section 4 deals with part-time public defenders, removes requirements for public defenders to report results of defendants' financial circumstances to the judge. Section 5 is an accurate definition of managed assigned counsel program services. Section 6 lays out policy when the MAC attorneys may withdraw or may be removed from a case, confidentiality of attorney-client or attorney work product materials. Section 7, MAC director designee to approve fee vouchers, pay attorney expenses to meet clients held in out-of-county jails. Section 8 covers reimbursing counties for public defender office costs for representing indigent inmates. Section 9 through 11 covers providing managed assigned counsel programs with access to DPS's criminal history information. Section 12 covers making staff in public defenders' offices and managed assigned counsel programs home address information confidential in tax appraisal records. Section 13 authorizes investigators in public defenders' offices to access driver's license photos in the DPS database. Sections 14 through 18 have to do with effective date provisions. So those are the top lines on it. Obviously, there's a breakdown of it that I can provide if you all would like to. I want to just go over, those are the agreed to provisions that are coming over in an identical version from the Senate. If there are questions, I'm happy to dive into whatever I can and give it a shot. However, I'd suggest that the staff folks from TIDC who are here to testify might be able to be better positioned to answer those questions, as they have the ones that prepared this over the interim.
All right.
And if you could recognize me after the witnesses, I'd appreciate it.
Any questions for Speaker Moody? We certainly will. I'll recognize you.
Thank
to
you so
close.
much.
Okay. So the chair would call Scott Ehlers. And Mr. Ehlers, your affirmation shows you're testifying on behalf of Texas Indigent Defense Commission, and you're neutral on the bill.
That is correct. Thank you, Chair Smithy. Members, I'm Scott Ehlers, Executive Director with the Texas Indigent Defense Commission. As Representative Moody mentioned, this is what I would consider a consensus bill. We have a legislative work group process that we go through every summer before the legislative session, where stakeholders in the criminal justice system come to us with legislative proposals, and staff at TIDC have some proposals as well. It goes through the work group process. It goes through our Policies and Standards Committee. It then goes through the full board. And so basically all of these proposals have gone through that consensus work group process, and we've packaged them all together in one single omnibus bill, and that's where it's at. I can ask any particular questions about any of the specific provisions, but that's the process and how we got here.
Any questions for Mr. Ehlers?
Just a
Yes, Mr. Moody.
No, no questions, just a comment. I appreciate all the work that you and your staff put into this. I know hours and hours and hours go into this. I don't want to dive too far into what's not here anymore. But
Okay.
we have a significant pipeline problem for attorneys in certain regions of the state. This is going to be a constitutional issue because we are talking about rights of folks to have representation. And we continue to turn a blind eye to the pipeline problems. We have creative solutions that the group has come up with, including loan forgiveness, grant programs, trying to make sure that we have a sufficient number of attorneys in those regions to be able to represent these folks because they have that right. And I know that stuff is not been agreed to by the other side of the building. And I get that. That's the part of the process that we go through. But we have to answer that question at some point. Otherwise, we will be in a lawsuit about what we're doing to violate people's constitutional rights. That I think is just a fact. So that's not a question to you. I know that you're not here to opine on any of that. I just appreciate the good work that you all do trying to make sure that these these programs are up and running and as efficient as possible. Given the weighty nature of what we're dealing with here. So thank you.
And I would just add to that, Mr. Moody, it's the job gets more and more difficult all the time because of the shortage of lawyers that are willing to take on these indigent cases. So any other comment or question?
Thank you.
Okay. Thank you very much for being here.
Thank you, Chairman Smithy.
Is there anyone else here to testify for, against, or on House Bill 4915? Seeing none, Chair recognizes Mr. Moody to close.
Thank you, Mr. Chairman. I guess I could have used my closing to give my speech rather than talk at Mr. Ehlers. But anyway, that's my point. I think there's some things that obviously there are very good things that are contained in here. These are ideas that have come across in very broad discussions and negotiations. But I'd say that there still is a ways to go on this front, but this is a good step forward. And if there's no questions, I close.
Okay. If there's no objection, any questions? If no questions, if there's no objection, the chair will withdraw the substitute to House Bill 4915 and leave House Bill 4915 pending. And Mr. Moody, while you're up, do you want to do 5465 as well?
Sure.
The chair, we have only one witness on that. So the chair lays out House Bill 5465 and recognizes Representative Moody.
Thank you, Mr. Chairman and members. House Bill 5465 is an omnibus bill as well, and this is for the Texas Judicial Council on Mental Health. You'll notice that it has no fiscal note. It's a bill about the procedures we use for people with serious mental health issues in our justice system. One unfortunate thing about our justice system is that it's often the catch-all for people with serious mental health issues who might have not ever been involved with law if they had proper treatment. By the time there's an arrest, people are sometimes pretty far gone, and our system isn't well equipped to deal with them at that point. This leaves us with worse outcomes for public safety, ineffective accountability, and a strain on law enforcement officers, prosecutors, and courts that we haven't given the tools or resources they need. This bill is aimed at making lots of small changes meant to improve our processes. I will say that it's a very technical area of law, and the folks on the Judicial Council are subject matter experts. So you may want to dig into the details with the witnesses that are here rather than me, but I'll give you a high-level overview. Current law requires our law enforcement agencies to make a good faith effort to divert people who could be charged with nonviolent misdemeanors other than DWI-related offenses to mental health or substance abuse treatment where it's appropriate. Often you're going to get better results delivering someone who's in a mental health crisis to a mental health provider than the county jail. And when we're talking about, specifically when we're talking about petty offenses. The bill expands on that by requiring a formal policy to be adopted by each agency and submitted annually to their governing body and to TCOL. The bill also makes extensive changes to how mental incapacity is dealt with in justice and municipal courts, where fine-only offenses may be dismissed after certain findings and procedures. That improves on the gray areas that exist in law today that can see our courts backlogged with ticket cases involving people who simply aren't fit to stand trial, and quite honestly, usually aren't in a position to pay for those either. The bill makes similar improvements to competency proceedings in more serious cases, which is a crisis point in our system today, with enormous wait times for beds at our state hospitals and limited options for competency restoration, even when the state, defense, and court all agree on what should be done. In particular, the bill expands the use of outpatient restoration where all parties and medical professionals agree, and which will hopefully ease some of the burdens on our limited inpatient facilities. And it also has provisions for civil commitments to residential care for certain defendants who have been found incompetent to proceed to trial. Finally, the bill makes tweaks to our mental health specialty court programs and to what orders courts may issue under different timelines when dealing with these cases. All of these are designed to close gaps in the law and make sure our courts can do what they need to do to take care of these cases. Again, that's a very broad overview, and I'd suggest that the fine details might be better addressed by other witnesses that are planning to testify. I'm happy to answer any questions, but much like the last bill that you saw before you, the Judicial Commission on Mental Health is comprised of a whole host of folks, including judges, law enforcement, probation, parole, and people up and down, mental health professionals, obviously, of people up and down the system from all around the state. Created back in 2017, if I'm not mistaken. I've served as an ex officio member of that body since it was created. And so these are things that they vet through their processes over the interim, taking into account all the different viewpoints that come to the table in those conversations. So this is the net result of those conversations. That's what's before you today.
Thank you. Mr. Moody, any questions? We'll go ahead and call. We've got one witness.
Thank you, sir.
The chair would call Christy Taylor. Ms. Taylor, your affirmation shows that you're here as in the capacity of Executive Director of Texas Judicial Commission on Mental Health, and you're testifying neutral on the bill, correct?
Yes, sir. Thank you, Chair Smithy, the members, and Representative Moody for laying the bill out. I would add that we have a process similar to what you just heard from Mr. Eilers. We begin a year and a half before the session with a legislative research committee considering ideas from the field. We have 50 different commissioners, multidisciplinary, who bring problems and procedure that they see in their everyday lives. So we hope that these procedural changes add clarity where there are gaps in the statutes and improve efficiency for the judiciary and the mental health systems. They are focused on real-life problems. I can give you an example. The provision about court-ordered medication was brought to us by a district court judge in Grayson County, noticing that they wanted to use, in rare instances, the court-ordered medication procedures, but it is very difficult to have those psychiatrists in some of those more rural counties. So they wanted to expand who could write those certificates of medical examination to physician's assistants and those specialized nurse practitioners who are probably seeing the patients, defendants more regularly and have more information about them anyway. So these sort of good ideas are gathered in our legislative process, then submitted to the Texas Judicial Council, and are very much consensus ideas that have made it through that detailed process today. And I'm here to answer any questions for you.
Any questions for Ms. Taylor? Okay, thank you for being here. Is there anyone else here to testify for, against, or on House Bill 5465? If not, the chair recognizes Mr. Moody to close.
Thank you. I apologize for keeping my seat, but I'll close from here if that's okay.
Okay. Any other questions? If not, the chair, if there's no objection, the chair will leave House Bill 5465 pending, and the chair would now lay out House Bill 507 and recognize Representative Gervin Hawkins.
Good morning, everyone. Thank you, Mr. Chair and members. House Bill 507 strengthens the standards and structure surrounding the legal defense of indigent defendants in capital felony cases where the death penalty is sought. In Texas, we recognize that the stakes in death penalty cases are as high as they can be. House Bill 507 does not abolish, expand, or limit the death penalty. It purely addresses the quality of legal representation provided to indigent defendants in capital cases. The Sixth Amendment of the United States Constitution guarantees the right to effective legal representation. House Bill 507 is about making sure that right is meaningfully upheld for those unable to afford a private attorney when facing the death penalty. Many indigent defendants rely on court-appointed counsel to defend their lives in court. Yet, unfortunately, in the past, there have been instances where indigent defendants receive poor legal representation, leading to appeals, reversals, and in some cases, grave miscarriage of justice. House Bill 507 strengthens Texas indigent defense system in capital cases by one, posting qualified attorney lists publicly. House Bill 507 requires each administrative judicial region's local selection committee to publicly post online the list of attorneys who are qualified to represent indigent defendants in death penalty cases. This ensures transparency and accountability about which attorneys are available for appointment. It also allows the public and defendants themselves to have confidence that those appointed meet clear qualifications. Number 2, creating the statewide Capital Defense Training and Standards Committee. House Bill 507 establishes a new statewide Capital Defense Training and Standards Committee composed of 9 highly qualified members, including 2 judges selected by presiding judges of the judicial region, an experienced criminal defense attorney appointed by the president of the Texas Criminal Defense Lawyers Association, a chief public defender of the Regional Public Defense Lawyers Association, the chief capital defender of a county public defender office appointed by the executive director of the Texas Indigent Defense Commission, a member of the State Bar of Texas Committee on Legal Services to the Poor and Criminal Matters selected by the chair of the committee, 3 attorneys appointed by the executive director of the Texas Indigent Defense Commission. This committee will be responsible for developing statewide policies and standards for the representation of indigent defendants in death penalty cases. I'm working on a committee substitute that specifies the appointing entity responsible for placing the committee members. And I'm open up to any suggestions by this committee, the members here, and other stakeholders to determine which entity would be most appropriate. Importantly, members must have significant capital defense experience. Members must be licensed attorneys. Members must serve 4-year terms and may be reappointed. Members may not receive compensation for service, but they are entitled to be reimbursed for the actual and necessary expenses incurred in discharging committee duties. The members will be paid from funds appropriated to the Texas Indigent Defense Commission. Members cannot be prosecutors, law enforcement officers, or associated with prosecutorial agencies to avoid conflicts of interest. Number 3, setting clear and rigorous qualification standards. The statewide committee will adopt statewide standards covering training and educational requirements for appointed counsel, experience requirements including minimum years of criminal law practice, experience in mental health and mitigation work, which are crucial areas in death penalty defense, continuing legal education obligations to ensure attorneys remain up to date on best practices. This ensures that appointed attorneys are competent, experienced, and committed to providing effective defense. Number 4, removing deficient attorneys. House Bill 507 ensures that attorneys who have provided deficient representation in past capital cases are not automatically requalified. Local committees must assess whether prior deficient representation accurately reflects ongoing inability to provide effective counsel. If so, those attorneys will be removed from the appointment list. This provision is essential to protecting defendant rights and maintaining the integrity of the court system. Number 5, ongoing quality review of appointed attorneys. House Bill 507 requires biannual updates from attorneys to local selection committees, including lists of capital cases worked on and proof of ongoing training. The list of policies and standards adopted by the statewide Capital Defense Training and standards adopted by the statewide Capital Defense Training and Standards Committee on the Commissioner's internet website. Attorneys who fail to comply with continuing education and reporting requirements will be removed from the qualified list. This promotes a culture of continual improvement and accountability among defense counsel in Texas. Clarifications. Does this bill impact the death penalty itself? No. House Bill 507 does not abolish, expand, or limit the death penalty. It purely addresses the quality of legal representation provided to indigent defendants in capital cases. Is there a fiscal impact? Using fiscal note from last session, which I filed the same bill, at a minimum, committee members will not be salaried, but will only be reimbursed for necessary expenses. The Texas Indigent Defense Commission will provide administrative support using already appropriated funds. How does this impact local selection committees? Local committees remain responsible for selecting attorneys, but we use statewide standards for consistency across the state. This ensures representation quality is not dependent on geographic location, aligning with best practices recommended by the American Bar Association. Why is House Bill 507 needed? Past failures. Past cases show serious failures by appointed attorneys, including missed deadlines, missing hearings, and lack of client contact. Uniform standards. Current local variations mean some defendants receive significantly poor representation based on where they are tried. Public trust. Fair legal proceedings are strengthened when public have the confidence in the justice system and reduce the costly years of long appeals. In closing, I'd like to say this. House Bill 507 is a common sense bill that ensures those that are facing the most serious criminal penalties have qualified, competent representation. It strengthens indigent defense, increasing transparency, promotes fairness, and protects Texas from future miscarriages of justice. And one of the things that is clear, members, is that, as you well know, folks with means are able to do the research on attorneys. They know their backgrounds. They know their successes and their failures. Our indigent folks need the same right. So publicly posting names allows them to see who is in this space and who has had successes and who has had failures. With that, Mr. Chair, I'd be happy to answer any questions and/or I reserve my right to close.
Okay, just a couple of announcements before, let me interrupt. So I need to announce that House Bill 4697 by Representative Linda Garcia has been withdrawn at her request. It was on the agenda for today. The other thing is, when we finish this bill, we're probably going to have to break for session. So if we have any, we've got some other authors here. And I'm sorry to do that to you, but if you could, I wanted to give you a heads up that we'll probably have to break as soon as we finish this bill. So then I will ask any questions for Ms. German Hawkins. Okay, we'll call the witnesses that we have then. Oh,
Thank you.
Ms. Jones. Oh, okay, I'm sorry, I didn't see. The chair calls Amanda Marzullo. Ms. Marzullo, once again, you're here, your affirmation shows that you're here testifying on behalf of the Austin Community Law Center and yourself, and you are for the bill.
Yes, thank you so much. And for those of you who don't know me on this committee, I previously was the executive director of the Texas Defender Service, and which handles capital cases throughout Texas. And I'd like to thank Representative Gervin Hawkins for her ongoing commitment to this issue. One thing that she didn't mention in her layout is that we have an aging capital defense bar, which means that every year fewer and fewer attorneys are actually able to handle these cases as first chair, and that our statute right now creates a catch-22 for defense lawyers. You have to try a capital case. Sorry. You have to try a capital case in order to be qualified to handle one, which means that some lawyers that like to try their cases, it can be a lucrative business, are always being appointed to handle the cases, and they don't always do the best job, while some of the most conscientious lawyers who are willing to make a deal that's in their client's interest are unable to graduate to the higher levels. So this bill creates sort of a flexible standard that allows for training that is to the specific issues in capital cases, ensures that experienced attorneys are equipped to handle these cases and then screened. It has worked in other jurisdictions. So Louisiana and Tennessee have similar programs. They work quite well. What really happens is that they have a vigorous defense bar that's ready to handle these cases. And that's one reason why those two states have fewer people on the row. And I'm happy to answer any questions that you might have.
Any questions for Ms. Marzullo? Ms. Jones?
So, I haven't. So is there, will the commission provide opportunities for, I'll call them baby lawyers, to sit second chair? I just remember when I was a baby lawyer, I didn't feel comfortable taking a murder case because I didn't want somebody to get locked up because I was learning. And so I tried 6 murder cases, second chair, with somebody. He didn't pay me a dime, but I was there to learn. Before I took my first murder case, which I think my first 2 murder cases, I got no bill because I knew what I was doing. By the time I took my own, So is that what you have? Something like that?
Well, it's a bit more modified. So under the statute, you're entitled to 2 lawyers, a first chair and a second chair, and they have different qualification criteria. So it's really up to the local selection committee who they want to qualify to be second chair. I think that said, there are a lot of cases where you see third and fourth chair on death penalty cases because people want to be involved and to learn more about this practice. Does that answer your question? It won't be required.
I just remember when I was carrying briefcases and stuff back then, that I did most of the grunt work and learned basically how to think my way and analyze my way through a murder case, and I think that there's value to that, so that the first time you're trying a case is not the first time you're trying a case. And so that's what I was just trying to figure out.
So that isn't part of this. The training program is really to make sure that lead lawyers understand things like the jury selection process in capital cases. You voir dire pretty rigorously in any case, but in death penalty cases, you have to be specific to the issues of the death penalty. And it's also just an administrative hurdle. A lot of the things that I used to do at Texas Defender Service was just assist the trial attorneys in organizing their juror questionnaires, making sure that they reviewed them accurately and knew what questions to ask when the juror was up. And so it's things like that that they'd be focusing on.
All right, thank you.
Any other questions? Thank you, Ms. Marzullo, for being here. The chair calls Benjamin Wolf. And Mr. Wolf, your affirmation shows that you're here testifying on behalf of the Office of Capital and Forensic Writs, and you are neutral on the bill, correct?
Yes. Thank you, Chair, members. 24 years ago, Texas passed the Fair Defense Act, and this was a landmark piece of legislation that sought to ensure quality representation through the setting of standards. And as Ms. Marzullo just referenced, capital work is highly specialized. It's different than regular criminal defense. There's a whole different amendment that applies. The current statute uses prior capital trial experience and appellate experience as a proxy for quality. But what we have right now is some jurisdictions, some areas of the state. The 7th region, for example, has exactly 2 attorneys who are on the first chair list. The same 2 attorneys are on the second chair list, and 0 attorneys are on the appellate list. And so what this bill does is, and as Ms. Marzullo articulated, it modifies the prerequisites in order to increase the pool of attorneys that qualify for appointments in these most serious of cases, while taking steps to ensure quality, making sure that they're up to task. Unfortunately, the situation in Texas is that with capital representation is that quality remains an issue in different parts of the state in different cases, and it is in efforts to broaden the pool, I would submit that it's important to ensure quality as well.
Thank you for your testimony. Any questions, members? If not, thank you for being here.
Thank you.
Mr. Wolf. Chair calls Burt Butler. And Ms. Butler, your affirmation shows that you're Burt Butler. You're testifying as on behalf of Texas Defender Service and yourself, and you're for the bill, correct?
Yes, I am. Good morning. I'm here to testify in support of HB 507. At my organization, we do a lot of consulting work with trial attorneys at the capital level in the state of Texas. And we believe that this bill accomplishes two really important goals. The first is it takes steps to deepen the bench of attorneys available to try capital cases in the state of Texas. This is important because we are suffering from a lack of qualified attorneys to accept these cases. Second, HB 507 accomplishes this without compromising the quality of court-appointed counsel. It is essential that capital defendants have properly trained attorneys to represent them at the trial level. These cases are legally and factually incredibly complex. Capital cases have their own unique constitutional jurisprudence and include comprehensive sentencing hearings. If counsel are unqualified, the defendant may receive inadequate representation, and the result may be years of appeals and ultimately a retrial. HB 507 carefully walks the line of deepening the bench without compromising the quality of counsel representing people in these cases, and that's why we support this bill. Thank you.
Thank you for being here. Any questions for Ms. Butler? Not. Thank you very much. The chair calls Nicholas Mulberg. Mr. Mulberg had registered on behalf of himself against the bill, but will be shown as not testifying. Anyone else here to testify on, for, or against House Bill 507? If not, Chair recognizes Representative Gervin Hawkins to close.
Thank you, members. And Representative Jones, it is to build the bench. You know, this is a critical area. We're talking about critical cases. And HB 507 wants to close the gap and make sure everyone has fair and qualified representation. With that, Mr. Chair, I close.
Thank you, Ms. Gervin Hawkins. Ms. Jones has a question.
Really quickly, like the basketball analogy, I played too. And I would actually love to speak with you just about this, to just sort of see how stuff is set up. But I support it.
All right, thank you.
Okay. Thank you very much. If there's no objection, the chair will leave House Bill 507 pending. And members, at this time, the committee will stand in recess pending the adjournment or recess of the if there's no objection, the chair will stand in recess until final adjournment, recess of the House, or during bill referral if permission is granted. Is there objection? Hearing none, the motion prevails. Committee stands in recess.